This is Tom Duty, middle-aged American, living in New Jersey near the Lincoln Tunnel. If you were to visit my website, you would type Howdy Doody into Google. You'll find the correct spelling of the famous puppet. You then combine Tom Duty in a Google search for my site. I'll be reading the second part. It's not broken by them. It's broken arbitrarily by me. A very long Uber portier services agreement. And I've come outside to do this. I've done this in cold weather. I've come outside to do this just to attempt to have some visual stimulation. If anyone decides to listen to this very long, me reading a legal document produced by Uber, then the least I could do is give you some visual stimulation so you get some imagery of my barrio. And when it was cold, I would set this up in the apartment, and I would come outside, and I'd kind of be ready to go. I thought, I don't really need to do that. The weather is warm. And then I got out here, and I thought, oh, I forgot the sun. So these So listeners, I have the time. I plan to finish the second hour of this exceedingly long text. But in order to read in the sunlight, I got to turn my screen up on this device. So I have 3 devices that the battery needs to survive till the end for me to finish. And 2 of the devices do not need a screen. The third one does need a screen. So it's that third one that's in jeopardy. So in a Uber registration, there's a simple checkbox check that you agree. I, of course, checked it. I'm now registered. I'm preparing to do my first delivery, evening. Right now it's the middle of the day. But I promised myself I would read and document all the stuff so I don't get myself in trouble like I did with Postmates. In the event, I attracted, for the single most popular topic I've done on my YouTube channel is Postmates. Now, no single video is especially that popular, but in total, I did so many hours on Postmates that it accumulated a lot of hours of listening. So listeners, if you're one of those persons and you returned here, and you might wonder the connection between me getting my account frozen on Postmates and how it might relate to Uber, it's exactly the same thing. I came to the point in the text that I came to understand is the reason I got my account frozen and that wasn't just frozen, it was terminated, never to be reopened again. If I would resume with Postmates, which it is my understanding that I am eligible. If I were to do that, I'd have to do it with a new account. Postmates is now spamming me, which tells me that maybe that's changed. I'm not looking into it because Postmates doesn't cover the area where I want to work and Uber Eats does. So where I fell prey to the systems of Postmates is with a low rating. Now, I thought I was being careful and I was not being careful enough. So what exists with Postmates also exists with Uber. The rating is calculated by the app, which is Uber Global. The rating was calculated by the app, which is Postmates Global, but the standard of what you have to achieve is calculated locally. So I just felt like if it was important, it would have been communicated more consistently than it was. And that was my miscalculation. That's the same potential to miscalculate exists with Uber. That said, I resume, and I think I'm going to get through this hour of reading, provided my battery survives. Limits: the liability company and its affiliates shall not be liable under or related to this agreement for any of the following reasons based on contract, tort, or any other legal theory, even if a party has been advised of the possibility of such damage. Any incident, punitive, special, exemplary, consequential, or other indirect damages of any type or any kind, your or any third party's property damage or loss, or inaccuracy of data, or loss of business revenue, profits, use other economic advantage except the company's obligation to pay amounts due to the pursuant Section 4 above, subject to any limitations or other provisions contained in this agreement which are applicable thereinto. In any event, shall the company of liability or its affiliates under this agreement exceed the amount of services, fees actually paid to or due the company thereunder in the 6-month period immediately preceding the events giving rise to such claim. Term and termination. Term: this agreement shall commence on the date executed by you and shall continue until terminated as set forth herein. The parties acknowledge that the term of this agreement does not reflect an uninterrupted service agreement, as this agreement guarantees you the right to choose when you make yourself available to each delivery service request and accepted via the provider app is treated as a separate service agreement. Either party may terminate this agreement for failure to timely cure a breach of this agreement upon 7 days prior to notice with any other party, immediately without notice or any other party's material breach of this agreement, or immediately without notice. In the event of insolvency or bankruptcy of the other party, or upon the other party's filing submission or request or suspension of payment or similar action of event against the terminating party. In addition, company may terminate this agreement or deactivate your provider ID immediately without notice with respect to you in the event of no longer qualify under applicable law or the standards policy of company and its affiliates provided delivery services to operate your transportation method or otherwise set forth in this agreement affects termination. Upon termination or agreement, you shall properly return to company devices and immediately delete and remove the provider app for your device. Outstanding payment obligations and sections 1.2, 2.4, 4.7, 4.8, 5.3, including but not limited to, shall survive the termination of this agreement. Relationship of the parties, except otherwise expressly provided herein, with respect to the company acting as limited payment collection agent solely for the purpose of collecting users on your behalf. The relationship between the parties under the agreement is solely that of independent contracting parties. The parties expressly agrees that the agreement is not an employment agreement, nor does it create an employment relationship between company and you. No joint venture, party, or agency.
Oh, Army, Mommy, there's a fire!
should company and you to joint venture partnership agency relationship exist between company and you. You have no authority to bind company or its affiliates, and if you undertake, do not hold yourself out as an employee, agent, or authorized representative of the company or its affiliates, whereby implication or mandatory law, otherwise you may be deemed an agent or representative of the company. You undertake and agreed to indemnify, defend at company's option, and hold company and its affiliates harmless from and against the claims of any person, entity based on such implied agency representative relationship. Miscellaneous terms. Any modification that the company makes to the terms and conditions of this agreement shall be binding on you, only your exception of the modified agreement, except as otherwise specifically provided herein. However, a company reserves the right to modify any information, references at hyperlinks, this agreement from time to time. You hereby acknowledge and agree that by continuing to use the Uber services or downloading, installing, or using the Uber provider app after such modifications are made, are bound by any future modifications to information referenced in those hyperlinks. Supplemental terms may apply to your use of the Uber services, such as the policies or terms related to certain features and functionality, which may be modified from time to time. Supplemental terms. You may be presented with certain supplemental terms from time to time. Supplemental terms are in addition and shall be deemed as part of this agreement. Supplemental terms shall prevail over this agreement in the event of a conflict. Servability. If any provision of this agreement is or becomes invalid or non-binding, the party shall remain bound by any provisions hereof. Any invalid or non-binding provision shall be severed or restricted in order to preserve as much parties' agreement as possible in light of the content and the purpose of this agreement. Assignment. Neither party shall assign or transfer his agreement to any of his rights or obligations hereunder, in whole or in part, without the written consent of the other party, provided that the company may assign or transfer its agreement to any or all of its rights and obligations under this agreement from time to time without consent. To an affiliate and acquire substantially all of the company's business equity or assets. Entire agreement. This agreement, including all supplemental terms, constitutes the entire agreement and understanding of the parties without respect to its subject matter, and replaces, and 15, supersedes all prior to contemptuous agreements and undertaking regarding such matter. In this agreement, the words including and include mean including, but not limited to. Words including and include mean including, but not limited to. The recitals form a part of this agreement. No third-party beneficiaries. There are no third-party beneficiaries to this agreement except as expressly set forth in the arbitration provision in section 15. Other than as provided in section 15, nothing contained in this agreement is intended to or shall be interpreted to create a third-party beneficiary claim. Notices. Any notice delivered by company to you under this agreement will be delivered by email, an email address associated with your account. By posting the portal available to you on the Uber services via the provider app, any notice delivered to you by the company under this agreement will be delivered by contracting company and partners.uber.com in contact section. Additional territory-specific notices may be required from time to time. Governing law, arbitration, except as otherwise stated in section 15.3, the interruption of this agreement shall be governed by the law of the state in which you perform the majority of delivery services, or if you have neither performed delivery services, the law of the state in which you reside, without regarding to choice or conflicts of law, provision, and jurisdiction. Any disputes, actions, claim, or cause of action arise without or in connecting with this agreement or Uber services are not subject to the arbitration clause contained in section 15.3, shall be subject to the exclusive jurisdiction of the state and federal courts located in those jurisdictions where you perform the majority of the delivery services. Or if you have never performed delivery services, the jurisdiction which you reside. These provisions do not apply to arbitration clause in sections 15.3. The delegation clause, section 15.3, or any arbitration disputes defined in 15.3. Instead, as described in section 15.3, the Federal Arbitration Act shall apply to such disputes, or if the FAA is found to apply in such disputes, the state law governing arbitration agreements in the state which the majority of your delivery services are not provided shall apply, or if you have never performed delivery services, the state in which you reside. The failures of the company to enforce any right or provision of this agreement shall not constitute a waiver of such right or provision unless acknowledged and agreed by the company writing. Other than disputes regarding the intellectual property rights of the parties, other claims identified in section 15.3, any disputes, actions, claims, or action arising out of connection with this agreement or Uber services shall be subject to arbitration pursuant sections 15.3, 15.3 arbitration provision. Important note regarding the arbitration provision, except as otherwise provided below, arbitration does not limit or affect the legal claims you may bring against the company. Agreeing to arbitrate only affects where any such claims may be brought and how they will be resolved. Arbitration is a process of private dispute resolution and does not involve the civil courts, civil justice, or jury. Instead, the parties decide in private arbitration selected by the parties using a process set forth herein. Other arbitration rules and procedures are also set forth herein. In arbitration, you will not be required to bear any type of fee or expense that you would not be required to bear if you filed an action in a court of law. Important. Otherwise, as provided below, arbitration provision will require you to resolve any claim that you have against the company or Uber on its individual basis, except as otherwise provided below. This provision will also preclude you from initiating, participating in, recovering any relief. This provision will also preclude you from initiating, participating in, or recovering any relief in a class, collective, or representative case against the company, Uber, or its affiliates. The ability of claim or actions under the Private Attorneys General Act, California Labor Code, is addressed separately below. In Private Attorneys General Act section, if you do not wish or subject to arbitration precision, you may opt out of the arbitration precision by following the instructions provided in sections 15.3. Cases have been filed against Uber and its affiliates may be filed in the future involving claims by users of Uber services. You should assume that there are now and may be in the future lawsuits against the company, Uber, Uber's affiliates, alleging class, collective, and or representative claims on your behalf, including but not limited to claims related to tips, reimbursement of expenses, and employment status. Such claims, if successful, could result in some monetary recovery to you. These cases now include, for example, Zwanda versus Uber Technologies, case number Eastern Division of Michigan. Suarez versus Uber Technologies, case number Court of Appeals, 11th Circuit District, Middle District. Carey versus Uber Technologies, Northern District, Ohio. Labor versus Uber Technologies case, District of Florida, Olivares versus Uber, case number, Northern District, California, and UCSRA versus Uber Technologies et al., Northern District of California. This is not an exhaustive list, but is intended only to illustrate the cases that have been or may be filed in the future, alleged class, collective, and/or representative claims on your behalf. The mere existence of these class, collective, and/or representative lawsuits does not mean that such lawsuits will ultimately succeed. But if you do agree and do not opt out of this arbitration, you are agreeing in advance, except as otherwise provided in Section 15.3, that you will not participate and therefore will not seek to recover monetary or other relief for any such lawsuits in this agreement arbitration. You will not be precluded from bringing your claims against the company or Uber in individual arbitration. Whether to agree to arbitration is an important business decision. It is your decision to make, and you should not rely solely on the information provided in this agreement, as it is not intended to contain a complete explanation of the consequences. You should take reasonable steps to conduct further research and consult others, included but not limited to an attorney, regarding consequences of your decision, just as you will when making any other important business or life decisions. How this arbitration position applies: the arbitration provision is governed by the Federal Arbitration Act, except as otherwise provided. This arbitration applies to any dispute, past, present, or future, arising out of related agreement or information terminated in the agreement and survives the agreement. Nothing contained in this arbitration provision shall be construed to prevent or excuse you from utilizing any information preceded resolution or the agreement, if any. The arbitration provision is not intended to be subsequent for utilization of such procedures. This agreement shall be governed by the FAA, even in the event arbitration provision is found to be exempt from the FAA as a matter of law. Any disputes in this regard shall be resolved exclusively by an arbitrator. In the event the arbitrator determines the FAA does not comply, the state law governing arbitration agreements in the state in which the majority of the delivery services are provided shall apply, or have never been performed delivery services, the state in which you reside, except as otherwise provides. This arbitration procedure is intended to apply the resolution of disputes and otherwise would be resolved in the court of law before any other forum or any other arbitration, with the exception of proceedings that must be exhausted under the application of law pursuing the claim in court or law in any forum other than arbitration. Except in otherwise provides, this arbitration provision requires that such disputes to be resolved only by an arbitrator through final and binding arbitration on an individual basis only, and not in any way in the court or jury and trial, or by the way, class collective representative action, except as provided in Section 15.3. Below, regarding class action waiver and PAGA waiver, such disputes, including disputes arise out of or relating to the interpretation, application, enforceability, revocation, validation of this arbitration provision or any provision of the agreement. This also includes disputes regarding whether arbitration provision is governed by the FAA. All such matters should be decided by an arbitrator and not by a court or judge as set forth. The preceding sentences in this paragraph shall not apply to disputes relating to the class action waiver or PAG waiver defined below, including these interpretations: enforceability, revocability, or validity, except as otherwise provided. This arbitration provision also applies to all disputes between you and the company or Uber, as well as the disputes between you and the company or Uber's fiduciaries, administrators, affiliates, subsidiary parents, and all successors, the assignees, any of them, including but not limited to any disputes arising out of related to this agreement and disputes arising out related to your relationship with the company or Uber, including the formal termination of the relationship. Except as, if otherwise, this arbitration provision also applies to dispute regarding any city, county, state, federal, wage hour law, trade secrets, unfair competition, composition, breaks and rest periods, expense reimbursement, termination, harassment, retaliation, description, and class arising under the Uniform Trade Secrets Civil Rights Act of 1964, Americans with Disabilities, Age Discrimination in Employment Act, Family Medical Leave Act, Fair Labor Standards Act, Employment Security Income, except for individuals' claims for employment benefits under any benefit plan sponsored by a company and covered by the Employee Requirement Income Security Act of 1974 or funded by insurance, Non-Discriminatory Act, and states or statutes, if any, addressing the same or similar subject matters and other similar federal, state, and or local statutes and common laws. This arbitration provision is intended to require arbitration of any claim or dispute that lawfully can arbitrate, except those claims and disputes which by terms of this arbitration provision are expressly excluded from arbitration. Uber Technologies is an intended third-party beneficiary of this agreement and the arbitration provision. As under this arbitration provision, the company and shall deem include Uber Technologies limits of how this arbitration procedure applies, disputes, claims, and requests for relief set forth. Below shall not be subject to arbitration, and requirements of arbitration set forth in this arbitration provision shall not apply. Claim for workers' compensation, state, disability insurance, employment insurance, benefits. Disputes are not permitted to be subject to a pre-dispute arbitration agreement pursuant to applicable federal law or Executive Order 19. If court competent jurisdiction finds a PAGA waiver set forth below in section 15.3 to be unforeseeable or invalid for any of the representative claim brought under the provision attorney California Labor Code, disputes regarding you or the company's or Uber's intellectual property rights. Furthermore, nothing is arbitration provision prevents you from making a report or filing a claim or charge. Equal Opportunity Commission, U.S. Department of Labor, Security Exchange Commission, National Labor Boards, or offices of federal court, compliance programs, and nothing in this agreement or arbitration provision prevents the investigation by a government agency or any report, claim, to charge otherwise cover this arbitration provision. Nothing in this arbitration provision shall be deemed to preclude or exclude a party from bringing an administrative case before the agency in order to fulfill the party's obligation to exhaust administration remedies before making a claim of arbitration. Selecting the arbitrator and location of the arbitration shall be selected by mutual agreement of the company and you, unless you and the company mutually agree. Otherwise, the arbitrator shall be an attorney licensed to practice the location where the arbitration proceeding will be conducted, or retired federal or state justice officer presided in the jurisdiction where the arbitration will be conducted. If the parties cannot agree on arbitration, then an arbitrator will be selected using an alternate strike method from the list of 5 neutral arbitrators provided by JAMS, Judicial Arbitration and Mediation Services. You will have the option of making the first strike. If a JAMS arbitrator is used, then JAMS streamlined arbitration rules procedures will apply. However, if there's a conflict between the JAMS rules and arbitration provision, the arbitration provision shall govern. Those rules are available at JAMS website. The location of the arbitration proceeding will be no more than 45 miles from the place where you provide the major of the delivery services under this agreement, or if you have never performed delivery services from the city in which you reside, unless each party to the arbitration agrees in writing. Otherwise, starting the arbitration claims and subject to the same statutes and limitations would apply in court. The party bringing the claim must demand arbitration in writing and deliver writing demand by hand or work class mailed to other parties within the applicable statute limitations period. Demand for arbitration shall include identification of the parties and a statement of the legal factual basis of the claims and significant remedy. Any demand or arbitration to the contact following address, Legal Portier LLC, Market Street, San Francisco. The arbitrator shall resolve all disputes regarding the timeless or property and demand of arbitration. A party may apply a party may apply to a court, competition, jurisdiction, temporary or preliminary injunctive relief in connection with arbitratable controversy, but upon the ground the reward the party may be entitled may be rendered ineffectual or such provision relief. How arbitration proceedings are conducted in arbitration, parties will have the right to conduct adequate civil discovery, bringing positive motions to present witnesses and evidence needed to present their cases and defenses, and dispute in the regard shall be resolved by the arbitrator. You and your company agree to resolve any dispute that is arbitrated and subject to this arbitration provision on an individual basis and not on the class collective action lawsuit. Representative basis, the waiver, the arbitration shall have no authority to consider or resolve any claim or issue a relief of any basis or any individual basis. The arbitrator shall have no authority to consider or resolve any claim or issue and relief on a class collection or representative basis. The term representative in this paragraph includes all representative actions that are subject to arbitration provisions except for claims under the Private Attorneys General Act, Labor Code. Your ability to assess or obtain the PAGA claims assessed separately below or subsequent entitled Private General Act, notwithstanding any other provision of this agreement, provision shall jam streamline arbitration rules regarding the enforceability, revocability, validity of class action waiver may be resolved by a civil court, a competent jurisdiction, and not by an arbitrator. In any case in which the dispute is filed in class collective representative action, there is a final judicial determination that all part of the class action lawsuit is unforeseeable. The class collection and or representative action, to the extent that the litigant litigated in a civil court competent jurisdiction, but the portion of the class action waiver that is enforceable shall be enforced in arbitration, while the company enforceable action, while the company will not take any retaliatory action in response to any exercise of rights you may have under Section 7, the National Labor Relations Act. If any, the company shall not be precluded from moving to enforce its rights under the FAA to compel arbitration on the term conditions set forth in this arbitration provision. Private Attorneys General Act, to extent permitted by law. Your company agreed not to bring a representative action on behalf of others under the Private Attorneys General Act, California Labor Code. In any court or arbitration, the waiver shall be referred to as the PAGA waiver, notwithstanding or any provision in this agreement or the arbitration provision. The validity of the PAGA waiver may be resolved only by a civil court, a competent jurisdiction, and not by an arbitrator. If the PAGA waiver is found to be unenforceable or unlawful for any reason, the unenforced provision shall be severed from the arbitration provision. Severance unforeseen provision shall have no impact whatsoever on the arbitration provision or the parties' attempts to arbitrate any remaining claims on the individual basis pursuant to the arbitration provision. Any representative actions being brought to the PAGA litigant and to have a civil court competent jurisdiction according to section 15.3 of this arbitration provision. If PAGA waiver is found to be unenforceable or unlawful, any reason the parties agree that the litigation of any representative PAGA claims in the civil court competent jurisdiction, the arbitration, each party will pay the fees for his or her own attorney subject to the remedies in which the party may later be entitled to under applicable law. Prevailing claims and provisions awarded responsible attorneys fees to the prevailing party. In all cases where it requires law by agreement, companies or its affiliates, the company will not pay the arbitration and or arbitration fees. If under applicable law, a company is not required to pay all arbitrators and or arbitration fees, you will not be required to bear any type of fee or expense that would be required to bear if you had filed any action in a court of law. Any disputes in that regard will be resolved by the arbitrator as soon as practical after the arbitration is selected, and companies shall bear all arbitrators and arbitration fees until such time as the arbitration resolve any such dispute. The arbitration hearing and award, the parties will arbitrate their dispute before the arbitrator, who shall confer with the parties regarding the conduct of hearing and resolve any disputes the parties may have with regard within 30 days of the closing of the arbitration hearing or within a longer period of time as agreed by the parties as ordered. The arbitration, any party will have the right to prepare any other party in the arbitration a brief. An arbitrator may award the party any remedy to which the party is entitled under applicable law, but such remedies shall be limited to those would be available to the party in the individual capacity of the law and claims presented by the arbitrator, and no remedies otherwise would be available or individual court of law forfeited arbitration provision. The arbitrator will issue a decision or reward in writing stating the essential findings of fact and conclusions of law. A court is competent jurisdiction shall have the authority to enter a judgment upon made pursuant to the arbitration. Your right to opt out of arbitration is not a mandatory condition or a consensual relationship with the company. If you do not want to be subject to the arbitration provision, you may opt out of this arbitration provision by notifying the company in writing of your desire to opt out of this arbitration provision by sending within 30 days of the date of this agreement executed by you electronic mail to optoutportier@uber.com. either from the email address associated with your delivery provider account, or identify that email address in the body of emails, starting your name clearly and writing your intent to opt out. Arbitration provision by sending a letter to the U.S. Recognized Delivery Services, Federal Express, example UPS or Federal Express, or hand delivered to Legal Portier, San Francisco. In order to effect the letter under option, must clearly indicate your intent to opt out of the arbitration provision. Must be dated and personally signed. The envelope containing the letter must be received if delivered by hand or postmarked within 30 days of the date of 22 is executed by your writing opting out of the additional provision, whether sent by will be filed in the company of the agreement maintained by the company. Your decision to opt out of the arbitration provision will relieve you only of your obligation to arbitrate. The dispute specifies in this arbitration provision and does not relieve you of any obligation to arbitrate disputes that might arise under any other arbitration agreement to which you have with the company. Uber and or the Uber's affiliates may be bound. Similarly, your decision to opt out of another arbitration provision contained in any other agreement that shall be relieved to arbitrate the disputes pursuant to arbitration provision. You acknowledge that the agreement that if the company modifies a provision agreement other the provision section, you will not renew the opportunity to opt out of arbitration. You further acknowledge and agree that if the company modifies the addresses or hand delivery mailing or electronic mailing opt-out notices identified in this arbitration provision or the portion of the arbitration listing the illustrated class, punitive, and or representative classes against Uber and Uber affiliates, you will not have a renewed opportunity to opt out of arbitration. If, however, company modifies any provision of this arbitration provision and or addresses of the delivery and or mailing opt-out notices, the illustrative and or representative class pending against Uber and Uber affiliates and under affiliates, you will have a renewed opportunity to opt out of arbitration. In such circumstance, the day opt out, the begin your execution of modified agreement, changes for any information, reference, hyperlinks, or agreements or arbitration provide shall create a renewed opportunity to opt out. You should not opt out of this arbitration. Should you opt out of the arbitration within 30-day period, you or the company shall be bound by the terms of this arbitration provision. If you do not opt out, you will be bound. You have the right to consult with the counsel of your choice concerning this arbitration provision. You understand that you will not be subject to retaliation if you exercise your right or claims to opt out of coverage under the arbitration provision. Full and complete agreement relates to formal resolution of disputes, enforcement of this arbitration provision. This arbitration provision is a full and complete agreement relating to the formal resolution of disputes arising out of related agreement, arising to related delivery services. You may in the event any other portion of the arbitration agreement is deemed unenforceable, invalid, the unforeseeable or invalid provisions shall be restricted severe to arbitration procedure under order and much arbitration provisions as possible by clicking yes, I agree, or signing below. Such may be read with applicable law. You expressly acknowledge that you have read, understood, and taken steps thoughtfully consider the consequences of agreement that agreed or bound by terms and conditions and agreement have knowingly executed it, and that you are legally competent to enter this agreement with the company. By clicking yes, I accept or sign below and required by applicable law, company is deemed to have agreed upon, bound by agreement of your signature. Woo! Listeners, that I estimated that to be an additional hour, and I think it was less. It felt like it was less. So I estimated that just by the visual slide down the face of the cell phone, and it looked like it was about halfway. But this agreement is so long that just a little bit could, be 15 minutes, which puts 15 minutes into the first half and takes 15 minutes away from the second half. Whatever it was exhaustingly long. I am not going to go back to this point in the agreement. However, as much as this was just words written by lawyers that were never instructional or to be read by anyone, it does contain, I will see if I can find it. There is a special email address in here. And basically this entire hour was me, I'm going to try it this way, find and replace. Oh, that'd be great. There it is. Listeners, if any of you reached the end of this, or maybe you fast forwarded and got to the end and, looking for some possible justification for spending this time. So if you did nothing else, you got to this point and you're listening to me now, 2 hours, an estimated 2 hours of reading comes down to one useful, actionable point. You can, in the instructions here and probably no place else, you are, as an Uber person, a driver, within 30 days of signing this agreement, you can opt out dash portier at uber.com. So the instructions are in here. Again, if you want to do this, I'm going to do it myself. You write a simple email. It tells you what to say. OPTOUT-PORTIER arroba, that's the Spanish @ sign, uber.com. So that's OPTOUT-PORTIER at uber.com. Now, a simple email to that address exempts you from the requirements to arbitrate. So this company is huge, so huge, there could be a class action lawsuit in your favor. And if you do not opt out, you are excluded from any benefit of that class action lawsuit. So there is also statements that they will not retaliate against you. They cannot retaliate against you if you opt out. So I am going to opt out. If anyone were to ask me, should he or she opt out, I would say ask an attorney. I'm going to ask an attorney before I have a friend who's a paralegal. To me, he's equivalent to an attorney. And I will ask him before opting out. But as I read it, there is good reason to and no reason not to opt out. So I'm going to follow the simple instructions here and opt out. This is Tom Duty, middle-aged American living in New Jersey near the Lincoln Tunnel. If you were to visit my website, you would type Howdy Doody into Google. You'll find the correct spelling of the famous puppet. You then combine Tom Duty in a Google search for my site. Thank you for listening. Have a good day, good evening, or restful night's sleep. Ciao.